Great. Good afternoon, everybody. I'm very glad to see that there's a lot of interest on today's topic. I am going to just give people a little bit more time. I see there's still a lot of people joining us. So if everyone could please just wait a little bit, I would really appreciate it. And we'll allow people to keep on joining this workshop today. Thank you. We still have new people joining us, but while we wait, I just wanted to make some general announcements. Please note that we are recording this presentation today. And also, please note that at least I am able to see your camera. So if you wish to do so, you may turn it off or block it. So I'm going to continue with the general announcements as more people join our group. So as I stated earlier, the presentation will be recorded and the slides will be uploaded to our website at a future date so that you can reference them as well. The presentation is recorded and the general format of today's workshop will be reviewing of these slides, a review of the common questions and answers, and an evaluation towards the end of the presentation to get your feedback on your thoughts on today's information. Please note that due to the size of the group, we will not be able to take one-on-one questions during the presentation. However, we will provide you with information as to how you can send us a direct email with the details of your question. Great. Well, thank you everybody for joining us. Today's presentation is done by the Los Angeles Housing and Community Investment Department. We are the City of LA's department that is in charge of enforcing various rules, primarily in the section I work in. It's the rules related to the rent stabilization ordinance, or what is commonly known as the rent control laws. In addition to our typical work during the COVID period, during the local emergency period, there have also been some new rules that have been implemented, some new temporary protections that have been implemented, both at the city level and at the state level. So today we will be discussing the city rules, the state rules, and also a brief discussion on the upcoming Renters Assistance Program. There is a lot of interest in the city of LA, and I will briefly touch on that topic to provide everybody in this room that information. So first, I would like to ensure that everybody in this group is aware that today's presentation is specifically about properties located in the city of Los Angeles. It does not include any other city in the county or in the state, and it is not about the rules that are in place for properties located only in the county of LA, but not in the city of LA. Now, LA is pretty spread out. As you can see on the slide on your screen, we have a very small picture here indicating a red area, which is the city of LA versus the county of LA. County is obviously a lot bigger, and the city is just a portion of the county. So you want to ensure that you are aware if you are located or if your property is located in the city of Los Angeles, so that you have a better understanding if all of these rules apply to the property you live in as a tenant or the property you owned as a landlord. The easiest way to know that is by looking at your utility bill. Do you pay your water and power bill to the Los Angeles Department of Water and Power? If the answer is yes, then you are located in the city of Los Angeles. If you pay your bill to any other power company, Edison, or some other city's company, then you are not located in the city of Los Angeles. Once you have determined if the property is in the city of LA, the next thing that is important for both owners and tenants to know is whether or not the property is subject to the laws of the Rent Stabilization Ordinance, or short for RSO. The RSO has been in place since 1978 and covers some properties in the city of Los Angeles by providing regulation of rent increases, regulation of evictions, allowing only for just cause evictions, and for evictions that are not the tenant's fault, requiring relocation payment. Generally, a property in the city of LA will be subject to the RSO if it was issued a certificate of occupancy or a final permit prior to October 1st of 1978. Now, if you do not know if the property is subject to the RSO, you can text the letters RSO to the telephone number 855-880-7368. By texting the letters RSO to that telephone number, you will receive a series of questions that will allow you to identify whether or not your unit that you live in or that you own is subject to the RSO. So on the topic of the temporary eviction protections in the city of Los Angeles, I want to point out that regardless of whether or not the property is or is not covered by the RSO, the temporary eviction protections do apply to all residential units located in the city of LA. The screen you see right now shows you a list of the protections that are in place for tenants. Protection number 1 involves a tenant who is unable to pay rent due to a COVID-19 related financial hardship. These protections were put in place under the local emergency period of the city of LA, which started on March 4th of 2020 and are ongoing with no set end date. Nobody knows when the local emergency period will end, so it's ongoing. So these eviction protections apply until the local emergency period ends. If a tenant is unable to pay their rent during the local emergency period, then a landlord may not evict the tenant if the reason for the non-payment is related to COVID-19. So for example, if a tenant has lost their job, their work hours have been reduced due to closures, medical expenses due to COVID, even childcare expenses that have been triggered by the closure of the schools. If the tenant is not able to pay the rent during the local emergency period, the tenant will have 12 months after the emergency period ends to pay back the rent that becomes due during the emergency period. The 12 months cannot be later than August 31st of 2022 per state law. Tenants are not required to provide supporting documentation to prove that they have been financially impacted by COVID. So for example, if a tenant has been affected by getting reduced hours at work, they may likely have a letter from their employer, but they are not required to provide that to the landlord. However, we strongly encourage tenants to ensure that they keep a copy of all their supporting documentation should you need it in the future. Additionally, tenants are not required to sign a repayment agreement. All tenants in the city of LA who have been impacted financially by COVID-19 are protected from eviction during the emergency period and have 12 months to pay back the owed rent. If an agreement has already been signed between the parties, it is recommended that the parties seek legal advice to identify how that agreement impacts the tenancy protections. Landlords may not charge an interest rate or a late fee on unpaid rent that becomes due during the local emergency period if the tenant has been impacted by COVID-19. The second protection involves no-fault evictions. For example, typically under the RSO, a landlord would be permitted to evict a tenant for the purpose of owner occupancy or for the purpose of withdrawing the unit from the rental market under the Alice Act. However, during the local emergency period, this type of eviction is on hold, and evictions that are based on the Alice Act will have to wait until 60 days after the local emergency period ends. The third eviction protection in the city of LA is that landlords cannot evict tenants due to the presence of an unauthorized occupant, unauthorized pet, or a nuisance that is caused by COVID-19. An example of a COVID-19 related nuisance would be if there is an increase in the noise level in a unit due to children being at home due to the school closures. Now, earlier in the presentation, I pointed out that it's important for parties to be aware if the unit is regulated by the RSO or not. The main reason to understand whether or not it is an RSO unit is because there is a protection or a rent increase freeze only on RSO units. So for properties that are subject to the RSO regulations, a landlord may not increase the rent during the local emergency period and for 1 year after the local emergency period ends. Units that are not subject to the RSO are not regulated by the city's rent increase freeze. So to put it in a summary, the screen or the slide that you see in front of you gives you a breakdown of what landlords are allowed to do and what landlords are not allowed to do. So landlords cannot charge an interest rate or late fee on unpaid rent, and they cannot increase the rent for 1 year after the local emergency period ends for RSO units. However, landlords are allowed to collect an RSO and a SCEP surcharge at any time, so long as they give proper written notice to the tenant and so long as the landlord has paid the fees to the housing department. Owners can also collect a just and reasonable rent increase at any time if it has been approved by the housing department and if the owner provides proper written notice to the tenant. Lastly, a landlord can collect approved surcharges such as a seismic retrofit surcharge, a capital improvement surcharge. However, it must first be approved by the housing department, and the landlord has to wait 60 days after the end of the local emergency period. And that's the difference here. A regular rent increase, the landlord must wait 1 year. A seismic surcharge, a capital improvement surcharge, a landlord must only wait 60 days until the end of the emergency period. On this slide, you will see an image of a COVID-19 renter protections fact sheet. This fact sheet is found on our website, and it is a document that is required by the city law to be provided to all tenants. At any time the owner will serve an eviction notice. This document gives the tenants a summary of their rights under city law. And the second page of this document is a form that the tenant may fill out to notify the owners that they have been impacted by COVID-19. I would like to point out that even though the form is provided for tenants to complete and submit to the landlord, under the city law, tenants are not required to issue written notification to the landlord of their COVID-19 impact. Verbal notification would be sufficient. However, we suggest that tenants provide written information, written notice to their landlords as a way to document that they have informed the owner of the situation. So that is the summary of the current city law protections that are in place during the local emergency period. Now, separately from the city are the state law protections. And the state law protections do not replace the city law. They do not cancel the city laws on the eviction protections. The state law provides additional benefits to tenants. These state law protections were extended to June 30th of 2021 by Senate Bill 91. So the state law breaks up the protections that they offer tenants into two general categories. The first category is the time period between March 1st of 2020 through August 31st of 2020. During these months, a tenant who cannot pay their rent because they have been impacted financially by COVID-19 cannot be evicted for non-payment of rent for those months, so long as the tenant does one thing, and that is to give a declaration of COVID-19 related financial distress to the owner. This declaration must be given by tenants to landlords no later than 15 days after the tenant receives a notice of non-payment of rent. The landlord is required to include a blank copy of this declaration attached to the 15 notice to pay rent or quit. Now, since in the city of LA, a landlord cannot evict a tenant for non-payment of rent when they have been notified that the tenant was financially impacted by COVID-19, there may be, the majority of situations may be that the owner does not give a 15-day notice to pay rent or quit. If that's the case, then the tenant should give the declaration of financial distress to the landlord and be proactive about notifying the landlord. The requirement to give this declaration is under state law and is required if the tenant wishes to benefit from the state law protections. This protection during the time period of March 1st, 2020 through August 31st of 2020 is a permanent protection. The tenant can never be evicted for non-payment of rent for those months if the tenant gives the declaration to the landlord. The second category of protections under state law is for the time period between September 1st of 2020 through June 30th of 2021. During this time period, if a tenant cannot pay their rent as a result of being financially impacted by COVID-19, the tenant must do two things if they wish to obtain permanent eviction protections under state law. The two things a tenant must do are: number one, give a declaration of COVID-19 related financial distress to the landlord, either proactively when the owner does not serve an eviction notice, or no later than 15 days after receiving a notice of non-payment of rent. If the tenant does give a declaration of their financial distress to the landlord, but still receives a notice of non-payment of rent, the tenant should be sure to once again give the declaration to the landlord within 15 days of receiving the notice of non-payment of rent. The second thing a tenant must do to obtain permanent eviction protection is pay 25% of the rent that became due from September 1st, 2020 through June 30th, 2021. This 25% can be paid in installments, so weekly, monthly, every 2 months, or it could be paid all in full at the end of June 30th, 2021. A tenant a tenant is allowed to pay the full amount, the full 25% of all the months from September through June, so long as it's not later than June 30th of 2021. I would like to clarify an important difference between the city protections and the state protections. The state law requires that a tenant pay 25% during the months of September through June of 2021. And if a tenant does this, it will give the tenant permanent protection from eviction for non-payment of rent. However, the city law does not require that the tenant pay 25% of the rent for any of the months during the local emergency period. However, if the tenant cannot pay the 25%, then they only obtain temporary eviction protections, meaning that at the end of the 12-month repayment period, if the tenant has not paid the full amount, a landlord would be able to pursue all of their legal remedies, which may include eviction. Whereas under the state law, if the tenant pays the 25% of the rent, a landlord can never pursue an eviction in court for non-payment of rent for the months of September 1st, 2020 through June 30th of 2021. The 12-month period, the 12-month repayment period under the city is limited by state law to be no later than August 31st of 2022. And towards the end of the presentation, I will give some specific examples to help everybody understand the rule and see how it works. Now, under state law, there are several different types of notices and declarations in various languages that are available for the public. I would recommend that both tenants and landlords visit the state website, which is housingiskey.com. Once again, for those who are on their cell phones, that website is housingiskey.com. When you visit that website, you will see a folder for tenants, a folder for landlords, along with forms and information available to both parties. I wanted to share an example of the declaration under state law that a tenant would have to fill out and give to the landlord. This is also the form that a landlord would have to provide to the tenant attached to any notice of non-payment of rent. This form is available in various languages on the state website. The second page of the form will provide instructions to a tenant as to how to serve this notice, this declaration, to the landlord. The state law has some additional terms that owners and tenants should be aware of. First of all, similar to city law, a landlord cannot charge a tenant late fees. So that is consistent both at the state and the city levels. Secondly, under state law, a landlord cannot increase fees or charge a new fee for a housing service that was previously provided for free. So for example, if parking was given to the tenant as part of their rental agreement at no additional cost, the landlord cannot now remove that parking space and charge a fee in order to return that parking space. For those parties who already had an additional service fee in place prior to the emergency period, a landlord can continue to collect that additional fee, but cannot increase it. And then the third point is if a landlord is required to temporarily reduce or remove a housing service for the purpose of complying with a public health order, then the state law says that is not a violation of the rental agreement. And it is also not considered a reduction of housing services under the RSO. An example of this could be earlier last year, a lot of landlords had to close their common area pools. That type of situation would not have resulted in a housing reduction under the RSO and would not have been considered a violation of the rental agreement either. Even though both state and city laws give tenants either temporary or permanent eviction protections if they have been impacted by COVID-19, the tenants do, however, have to eventually pay back the rent that they owe the landlords. That could be in the form of a small claims or some other type of civil action, but under state law, it can never be an eviction action. And under city law, it cannot be an eviction action until after the end of the 12-month repayment period if the tenant did not pay the 25%. So before I go into specific scenarios and common questions, I wanted to provide the group some general information on the City of LA's Renters Assistance Program. This is the program that will provide financial assistance to tenants and landlords for the purpose of ensuring that rent or some amount of rent is paid. On your screen, you will see our website, which is hcidla.lacity.org. If you go on that website, you will see a message or you will see an update on our current assistance program. If you want updates, you could always go to that website, or you could also sign up for our newsletter to receive notifications via email. The program will open to the general public on March 30th. So in about a little less than 2 weeks, the program will be open for tenants to sign up and for landlords to sign up their tenants. Both the owners and the tenants can visit our website on March 30th and complete an application to initiate the process. The general eligibility requirements for a tenant to be eligible for the financial assistance are: number one, that they live in the city of Los Angeles. The tenant must live in the city of Los Angeles. Number two, that the tenant qualifies for unemployment benefits or has experienced a reduction in their income as a result of COVID-19. So for example, a loss of their job, medical expenses due to COVID-19 would qualify a tenant. And a tenant must also demonstrate that they would be at risk of experiencing homelessness or housing instability, which could be demonstrated by a copy of a notice of eviction or a notice of past due rent, or if the unit is considered to be unsafe or unhealthy for living conditions. One or the other is required, not both. And the fourth requirement is that the tenant's household income be at or below 50% of the area median. And our website has a chart that you will see that gives you the breakdown of the exact dollar amount per household size that would qualify for the 50%. One last note is that applicants will not be asked about their citizenship or asked to show any proof of citizenship in order to qualify for the program. If a tenant is selected, then there will be two possible options for the landlord. The first option is that the city will pay 80% of the tenant's past due rent for the period beginning April 1st of 2020 through March 31st of 2021. But the city will only pay the 80% if the landlord agrees to waive the remainder of the 20%. So if a tenant owes $1,000 in rent, the city will pay $800, but the owner must agree to never claim the remaining $200. So essentially, they give up the right to recover the $200. However, the landlord has a choice. If the landlord does not wish to waive the 20%, then a landlord could agree to receive 25% of the total rent that the tenant owes for the months of April 2020 through March 2021. Under the 25% rule, the landlord does not waive their option to recover the remaining balance of the rent that is owed. Please note that these rules are in alignment with the Senate Bill 91. So now I wanted to go over some common questions and answers that we have seen from the public that are probably many of the same questions that the group has. The first item or common question that comes up is people want us to explain the city's 12-month repayment period a little bit further. And so if you recall, the general rule under the city law is that a tenant will have 12 months after the end of the local emergency period to pay back the rent that is owed that became due during the emergency period. The emergency period started on March 4th of 2020 and is ongoing through today with no known end date. Furthermore, if you recall, even though the city gives a 12-month period of repayment, the state law has placed a limit as to how long that 12-month period can be. And it cannot be later than August 31st of 2022. And so to better understand the possible scenarios, I have two examples on your screen. Example number one assumes that the local emergency period in the city of LA ends on June 30th of 2021. If it were to end on that date, then starting the next day, July 1st of 2021, a tenant would have to start paying the full rent that becomes due the month of July, the month of August, September, and so on for the rest of the year. However, the months during the local emergency period that the tenant was not able to pay or not able to pay in full, that period is protected under the city law if the tenant informs the owner that they were impacted by COVID-19. And under the city law, the tenant will have 12 months to pay that rent. The 12 months in example number one would be June 30th of 2022. So in example number one, a tenant does not get until August 31st of 2022 to pay. A tenant would only get until June 30th of 2022 to pay back the owed rent. Example number two is a little bit different. Example number two assumes that the city's local emergency period ends on September 30th of 2021. In example two, that would mean that on the next day, October 1st of 2021, the tenant would have to start paying the full rent that became due starting October forward. So if the lease agreement says rent must be paid on the first of the month, then October 1st, 2021, the tenant would have to pay the full rent, regardless of whether or not they were impacted by COVID. However, the months during the local emergency period, which under example number two would have been March 2020 through September 30th, 2021, those months are still protected, and the tenant would have 12 months to pay back that rent. However, if you recall, the state law says the repayment period cannot be more than 12 months. I'm sorry, cannot be later than August 31st of 2022. Um, and actually that should be a 30th. So under the state law, even though the emergency period ends in September of 2021, the tenant would not have until September of 2022. The tenant would only have until August of 2022 to pay back the rent. So it would not be 12 months, it would be 11 months. Now, a few other common questions. Some of these are more landlord specific. Oftentimes owners want to know if they can enter the units of the tenants for either showing the units or even for making repairs. So that can be a changing answer depending on where the city is at with the Safer LA order. The Safer LA order is constantly being updated, and you can find the most recent version of that order on the mayor's website, on the mayor's COVID-19 orders website. And I do have the link on your screen, and it's a little bit long, but it's lamayor.org/COVID-19 orders. At that website, you will find a list of all of the city orders. The first one is the Safer LA. That order specifically discusses the restrictions for businesses, including in the context of real estate. And we'll discuss what type of measures a landlord must take before entering a unit, a tenant's unit, assuming they can even enter the tenant's unit. Landlords oftentimes want to know, how do they recover the unpaid rent? So the general rule, the general answer would be that owners must be sure to follow both the city and state law notification requirements whenever they issue a notice to pay rent to a tenant. And if a tenant informs the owner that they have been impacted by COVID-19, then under city law, the owner has to wait 12 months after the local emergency period ends to try to recover the rent that is owed in any kind of legal action. We strongly recommend that landlords seek legal advice when initiating any type of action to recover rent due, to ensure that you're in compliance with both the city laws and the state laws. Another common question is, what if the owner does not want to accept the rent payment or does not want to apply 25% of the rent payments to the protected months? So we suggest that both tenants and landlords carefully document all rent payments that are issued by the tenant. So keep copies of money orders, copies of canceled checks, copies of any notices or declarations that are provided from the tenant to the landlord or from the landlord to the tenant, to ensure that you're documenting the exact actions of each party. And tenants should be sure to try to identify as best as possible what months they're paying for and what amounts they're paying. I do want to point out that the housing department does have an investigation section where tenants could file a complaint and would have a housing investigator assigned to them. That city staff would reach out to the landlord and try to reach a resolution. Parties at all times, of course, can seek legal advice. This question I discussed earlier, and that is, what if a tenant and landlord sign a repayment agreement already that is different from the city and state protections? The agreement would have to be reviewed by an attorney so that both parties can understand how that agreement specifically impacts the tenant protections. Next question would be, what forms do landlords have to give to tenants? So you have to keep in mind that you have both the city law and the state law. Landlords have to follow both. Under the city law, you have the COVID-19 sheet, COVID-19 protection sheet. It's one page, if you recall. And then the second page is the form for the tenant to fill out. Landlords must always give that when issuing an eviction notice to a tenant. Separately, a landlord must also give the state law notifications of tenant rights. And the state forms are found at housingiskey.com. The city forms are found at hcidla.lacity.org. So please visit both websites to be sure that you download the appropriate forms. Likewise, tenants may have forms that they have to give to landlords. And so the next question, I think really is for tenants, is what forms do tenants have to give to the landlord, and how do tenants serve these forms? So, of course, best practices is always to work closely with a legal organization. But the forms under state law, again, are found at housingiskey.com. And that specific form the tenant must give to the landlord is the declaration of COVID-19 financial distress. Now, if anybody in this group has additional questions or a specific scenario that they need assistance with, we do have a system by which you can submit your questions at any time of the day. There is a website link on your page, hcidla.lacity.org/ask HCIDLA. So it's a long link, I realize that. But if you Google HCI DLA, ask HCI DLA, you will find a link to a form that you can fill out to submit a question to our department. So again, just Google ask HCI DLA and you should find our form. You could also call our general hotline, which is area code 866-557-7368. And that at that hotline, tenants could also file a complaint, or tenants could also file a complaint online. Now the complaints, as I mentioned earlier, they are investigated, but we do our best to work with all parties to reach a resolution. So we want owners to know the rules. We want owners to comply. So we make sure to inform owners of that. And lastly, there is a web page that gives you a summary of all the renter protections. And you could go to our hcla.lacity.org website. And on the first page, you see it will have a folder that says renter protections. You can click on that and it will take you to the page. So that is all I have for today. I do know that we have an evaluation that you can do online. And if you see that on your screen, if you could please let us know what you thought of today's workshop, we would greatly appreciate it. And we'll give you a few minutes to complete that.